The first witness will be Mr. Squires. Mr. Bill Squires is the Senior Vice President and General Counsel of Blackfoot Telecommunications Group in Missoula, Montana, and is testifying on behalf of the National Telephone Cooperative Association. Mr. Squires, you will have 5 minutes to present your oral testimony.
Thank you, and thank you for the invitation to participate in today's discussion on controlling the reaches of federal agencies and considering modifications to the RFA. For the past 10 years, I have served as Senior Vice President and General Counsel of Blackfoot Telecommunications Group in Missoula, Montana. Blackfoot is organized as a cooperative, and as such, our priority is to provide to our customers, who are also our owners, the very best communications and customer services available. We serve only 21,000 customers in western Montana over an expanse of about 6,500 square miles, so only a little over 3 customers per square mile. We have approximately 140 employees, and in 2010 had operating revenues of $34 million. So we are a small, highly regulated company. The entrepreneurial spirit of Blackfoot is represented by approximately 1,100 small rural counterparts in the telecom industry, who together serve 50% of this nation's landmass, but only 10% of the population. Rural providers are early adopters of new technologies and services. Blackfoot currently offers 15 megabit broadband service to 98% of that 6,500 square mile service area. Territory. Thanks to rural telecom providers, rural Americans are enjoying universal voice services, access to broadband internet, and enhanced emergency preparedness. To counteract the natural inclination to develop a one-size-fits-all approach to regulation, the RFA was adopted in 1980. It directs agencies to balance the societal needs tied to federal regulations with the needs of small businesses. Though the RFA has been good for small businesses, many industry stakeholders believe that some agencies, and in our industry, particularly the FCC, gives little regard to the law and its mandate to thoroughly review the impact of proposed regulatory orders on America's small business community. The RFA is supposed to force agencies to be creative with regulatory alternatives. Instead of conducting this analysis, agencies often summarily state that alternative regulation was considered and rejected. Among the FCC's rules, for example, that have a significant and unnecessarily damaging financial impact on small carriers are things such as truth in billing, bill shock, slamming, customer proprietary network information rules. These are all laudable goals, and I don't question those today. However, in the instances where final rules have been adopted, the Commission did not fully analyze the impact of its rules on small businesses and did not fully explain why alternatives were rejected. In response to the FCC's continued disregard of the RFA, the National Telecommunications Cooperative Association actually sued that agency in 2004 over its new number portability rules, which were heavily skewed in favor of very large companies. The court forced the FCC to perform the required RFA analysis, and NTCA members offered suggestions on lessening the burdens that the rules would have on small businesses. The FCC rejected and ignored the suggestions of NTCA, and NTCA sued again, arguing that the analysis was deficient. Amazingly, the court stated that the RFA's requirements are purely procedural. It requires the agency to do no more than state and summarize issues. I simply can't believe that it was Congress's intent in passing the RFA. Because the FCC is an independent agency, it's largely not subjected to direct oversight by the OMB's Office of Information and Regulatory Affairs. The OIRA was created by Congress to review federal regulations and reduce burdens. Further, FCC is not required to comply with Executive Order 13272, which specifically deals with cooperation with the Small Business Administration's Office of Advocacy, nor is it subject to Executive Order 12866, which requires a cost-benefit analysis for all significant rules. We believe the following legislative actions could go a long way toward enhancing small business participation in the dynamic communications sector. Codify the appropriate provisions of the executive orders in a manner to make them applicable to independent agencies such as the FCC. Require all agencies to explain whether and how each rulemaking decision promotes and protects small businesses. Amend the RFA to clarify that all agencies must suggest and analyze creative alternatives that account for the nature and competitive position of small businesses when conducting rulemakings. Certainly consult with the Small Business Administration's Office of Advocacy well in advance of rules being adopted and specifically address any suggested authority. Provide the FCC with the responsibility to require agency bureaus to coordinate regulatory activities. Members of the committee, we're excited to have your attention today, and I appreciate the opportunity to be here. We're excited to have your leadership to develop policies that will give America's small businesses the confidence to invest and flourish. Thank you for the opportunity to be here today, and I look forward to answering any questions you may have.